Good evening, everybody. It's Wednesday, and so that means I'm welcoming you to another episode of Calenda, Attorney at Law, here on the Coalition Radio Network. I'm your host, Calenda, attorney at the law firm of Inman and Torgy here in Coventry, Rhode Island. And as usual, I'll be walking us through our subject matter tonight. Most importantly, I'll always be putting the law above politics. We're continuing the series where we touch on various legal issues facing us here in Rhode Island and nationally. Tonight, we're going to discuss some high-profile court cases coming out recently and some constitutional principles common in those cases. To help me discuss these issues throughout the episode tonight is attorney Mark Rutherford, owner of Thrasher, Bushman, and Vocal PC in Indianapolis, Indiana. He's also the former national vice chair of the Libertarian Party and the chairman of the Indiana Public Defender Commission. Mark, welcome to the show, and thank you for joining me tonight.
Chaz, it's my pleasure to be on the show, and I'm looking forward to it.
I'm glad to have such a distinguished guest to discuss some of these constitutional issues that are coming out in some of these most recent opinions won by the Supreme Court, and then particularly one that came out today that I'm sure everybody's talking about is the Bill Cosby decision by the Pennsylvania Supreme Court, reversing his conviction and barring his retrial. So before we get into that, I just want to have you tell our guests a little bit about yourself, what you do, and anything that you concentrate in.
Yes, I'm a business law attorney in Indianapolis, do a lot of litigation, a lot of contract review, represent a lot of entrepreneurs. But I also have a bent on constitutional law. I've got a case against the governor of Indiana that's going to have some argument in a couple of weeks concerning the separation of powers between the legislature and the executive. So I do get involved in that quite a bit. Also, as chairman of the Indiana Public Defender Commission, there's constitutional issues all over the place with what we deal with that.
Sure. So you're going to be very familiar with some of the things and principles that we're going to be talking about tonight, being the chairman of the Public Defenders Commission. But particularly, and we'll just kick it right off with this Cosby decision. I think we all saw back in 2005 when this first came onto the national scene that it was a fairly high profile case. I mean, everybody knows Bill Cosby, famous actor from, years and years, and was accused of some pretty serious sexual assaults. And, going back, reading some of the history in this case, looks like the district attorney in the county in Pennsylvania at that time had evaluated his case, potential criminal charges against him, and it made the decision that under no circumstances, due to lack of evidence, credibility issues with the complaining witness, and some other issues, that he made the decision that there was not going to be a prosecution, so the complaining witness could go forward in a civil matter. Doing so all while knowing, or his intent was to remove Mr. Cosby's ability to assert his Fifth Amendment privilege to remain silent in any civil proceedings that may follow. And as you know, what happened after that was the office changed hands. The civil proceedings took place first, I should say. The office changed hands to what was his first assistant deputy district attorney, and they decided to reopen the matter, not abiding by the original district attorney's promise not to prosecute. And the statements that Cosby made during his depositions, during the civil matter, were all used against him to eventually convict him in the Pennsylvania trial court. And today, the Pennsylvania Supreme Court said that was legally inequitable, essentially. Legally inequitable, and the promise by the district attorney at the time in 2005 should be enforced, and Cosby had relied on it to his detriment and was convicted wrongfully as a result. They really get into some strong language about what the role of prosecutor is, the role of equity in the criminal justice system, and I'm interested to get your take on how the court came down and how often you've seen a remedy this drastic in your practice.
You don't see a remedy this drastic very often because courts are reluctant to overturn juries. They want the process to go in the criminal justice system. So it's very, very rare. Usually what they do is they say a retrial. Let's do it. Maybe we do it more fair. Maybe we can't use what you said in the trial. Let's see if they still can convict you or not. But they said completely no. You're not going to be able to retry it. But this is a point I make to a lot of people, and to my clients often, to other attorneys, and that is if you're into the Court of Appeals of a state or the United States, a federal court of appeals, Supreme Courts, etc., they don't like legal I gotchas. And I think that they think that this is what the successor prosecutor, district attorney did, was it was a legal I gotcha. So that really infuriated them, and they decided it's not worth it. They shouldn't do a retrial. This is bad. From a contractual standpoint, maybe there was one. Maybe he had what's called detrimental reliance on that. But from my standpoint, if I had a client that the prosecutor said that, unless it's in writing that this is with prejudice and we can't do it, and Indiana has a process where you have to get a court to approve these type of things. I don't know about Pennsylvania. So unless you get that, I would say, you know, well, shoot, you're saying nothing. Don't civil trial, don't. You're probably going to lose it anyway. Cosby's had some from a civil standard, which is a lot less proof is needed to win if you're suing over it. It's about money, so it's basically 50% plus one means you win, slightly better case. So I wouldn't rely on that as it was, but now in Pennsylvania, I definitely would because of what they said, and they said it was an oral contract that's enforceable. There's evidence he made it. He had press releases, he had press conferences, and said, "I'm not charging him," so that the victim can go and sue him in civil court, and he has to testify.
Exactly. And one of the first things that struck me when I read this case was the complete oddity of the way the prosecutor went about conferring what he believed to be immunity on Bill Cosby. It certainly was not the way, like you mentioned, that has to be done in Indiana. Certainly not the way it's done in Rhode Island. Here, the prosecutor has to seek approval of the presiding justice of the Superior Court in order to grant a formal immunity to somebody, and that clearly was not done. And the Pennsylvania Supreme Court in their decision notes that, and they note that was not the basis of their decision. Their decision was more based on what you're talking about, a contractual remedy of specific performance. The fact that Bill Cosby relied to his detriment on not only the statement of the prosecutor, but his own attorney's advice based on the statement of the prosecutor, and those statements were then later used against him to convict him in this criminal trial. They said that it would be absolutely inequitable for him to be allowed to be not only convicted, but allow them to retry it. They just said it was they cannot avoid the injustice of it. I believe their words were, and
Yes.
and they actually quoted. I think and I'll get into it in a little bit, but they quoted the former U.S. Attorney General and Supreme Court Justice in talking about just how powerful the role of the prosecutor is. But I do want to pick up on something that you just said, is that in a situation like this where the so-called grant of immunity was so informal, I wonder what Cosby's attorneys were thinking when they didn't even attempt to try to get him to assert his Fifth Amendment privilege. Because, I mean, I agree with you that, my client's going through a civil case. There's no formal grant. They didn't go through the statutory process. There's nothing in writing except for a press release they admit, the Supreme Court admits, was ambiguous. I'd be telling my client, you assert the Fifth. I mean, you're probably going to lose your civil case, but you assert the Fifth because there is no guarantee, especially a case which probably did not have I don't believe this charge has a statute of limitations like a lot of sexual assault cases do, similar in Rhode Island. My client wouldn't be talking. I kind of found that I was a little at a loss for words. Everyone went through this process, and nobody tried to
Yeah,
assert his Fifth Amendment privilege.
yeah, and what I don't know if that was done or not. I assume it wasn't from what I've read. I haven't read the trial transcripts. They're probably voluminous. Whether that was done or attempted, the judge says, well, you do have to testify. I do not know that. What I also know is that from the perspective of representing clients, what is said and well documented in private letters and emails to clients often is, I don't advise you do this. This won't stop. This won't cause me to withdraw from the case, but I think you're making a horrible mistake. So I have no idea if any of that happened. So it's hard to second guess attorneys. But boy, I would be pounding on, nope, he's not going to testify. My recollection is they were at the end of a 12-year statute of limitation. So if they had waited a little while, then it would have been barred because the law said it was too old of a case for them to take to a criminal proceeding. So that's my understanding of also was in the background as well. But I do have to raise that sometimes clients say, well, they'll believe me and I'm going to testify and I think I've got good immunity. And nope, they've got a 3-page letter from me in case they ever say I was a bad attorney.
Right, and those are letters that people, anyone who represents clients, they're the CYA letters that you put in writing to them. So when they later come back and say that you didn't give them the correct advice or that you're the reason why they lost their case, you can say, well, this is what I advised you, but it was your decision, and you made the decision you made, and here are the consequences.
I mean, it is their case. I mean, they hire you, and where I would move to withdraw is where I don't think they're paying attention to me. But there are times that clients will make decisions, and you just go, I think it's the wrong one, but it is several of the options before you, and it's your life. I'm sorry, and here's my letter saying this was not the best of the 3 or 4 choices I recommended to you.
So one of the other issues I wanted to bring up in here, and myself, I'm not sure if you know this, but myself, I'm running to be the Attorney General for next year in Rhode Island.
Yes,
and
aware of that.
the role of the prosecutor, which they talk about in here, and to me, just kind of reading the background in this case, it looked like the original district attorney who made the non-prosecution decision was doing it based on the ability of or inability to win that case or secure a conviction in that case. And when that office changed hands, I believe it's an elected office in that county. When that office changed hands, it looked like those considerations were not being as thoroughly considered by the next district attorney. It looked like more of a, well, this is back in the news. This is more of a high-profile decision. The kind of atmosphere that was going on at the time, the Me Too movement was in full force and effect, may have been affected by some sort of political considerations. If that is, we have a high-profile potential defendant, some salacious charges. We have now statements by Bill Cosby that he made in his depositions and potentially in his civil trial that were salacious. And at the same time, now they're deciding to go back and we're going to give it a second look, despite the fact that our former elected official said we weren't going to do that. So it looked like to me that there may have been some political considerations when they brought the case back with the new district attorney. Did you get that impression?
Oh my goodness, yes. And sometimes it's political. Other times it's a little bit of political, and they just think the other prosecutor didn't make the correct call on it. I've seen that many, many times from prosecutors where I think, and sometimes I agree with them. I didn't know why they didn't charge somebody, that they were reviewing the evidence wrong. The other thing is, and there's a famous case in Louisville where they went ahead and tried somebody for murder and was acquitted. The case was not that strong. And then the guy sold his house, and the new people pulled up the carpet and found a little stash of pictures showing him kill the person. Well, they couldn't try him because he had already been acquitted of murder. So the prosecutors have to make that tough choice. Do I go ahead and try to remove this person who I think may be dangerous and get him convicted so the public is safe? But I may have weak evidence, and I may regret it someday because we'll find the evidence later and maybe we should wait. It's a tough call for district attorneys, prosecutors all the time.
Yeah, there's no question. Having been a prosecutor for 12 years myself, I certainly know what has to go into that charging decision. And one thing that I always believed, and I believe to this day, even though I'm doing criminal defense work for the most part in this day and age, one thing I always understood was, outside considerations which don't have any bearing on law and fact or anything that's outside of that should not be playing a role in what decision of whether or not somebody should be charged or not. And I think that the quote that they used by former Attorney General Robert H. Jackson, who was a Supreme Court justice apparently as well, later on in his tenure, that they quoted this in the case: the prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. And that's something that I think came into play here because, as you said, they may have thought they had a great case, but I don't know that they kind of went back and looked at everything the original district attorney looked at as far as what the evidence actually was, what their chances of an actual conviction was based on the law and the evidence available to them was. I think they did this more of I don't want to call it a publicity stunt, but more of a, here we are, we're going after a very powerful individual, a famous individual. We've got this salacious case and we're going to take it to the wire. And, they thought they had him, and they did have them for some years now, but they don't have them anymore. And it's kind of egg on their face. And I certainly wouldn't want to be in that position.
Justice Jackson's quote is right on target. It's a very, very powerful position. And if you are the district attorney or prosecutor, we just had one in Indianapolis who died yesterday. He had to resign in the middle of his third term because of cancer, unfortunately. But boy, was he good. He knew that, and it reflected things very well. And he usually didn't make what I would consider power mistakes or overzealous mistakes. He was very, very good. But boy, there are prosecutors who they have other reasons, and they may not respect. I've had doubts they respect the how much power they have to really mess up people's lives. So if you've got a person that needs to be rehabilitated, that's Indiana law, or you're scared of, which is also Indiana law, you need to prosecute them if they did something that was against the law. But boy, you better be careful that you are 100%, not 100% correct. Nothing can be 100%. Very little can be, but that you're really on the right direction, and before you do that, I think sometimes and I see sheriffs pushing back in Indiana on jail overcrowding, especially with mental health cases. There's a lot of pushback now to be better at picking the cases you prosecute. The federal courts, prosecuting attorneys, district attorneys, used to be really good at it. But I think with the pressure of Congress and all types of new laws, they're starting to lose cases. And it used to be they didn't try a case unless they were absolutely sure that they were going to win unless a witness changed their story in the middle of trial.
Absolutely right. And I've certainly had that experience. When I was in the Attorney General's office as a prosecutor, I was cross-designated in the U.S. Attorney's Office here in the District of Rhode Island, and trying to get them to take a case from the state level to the federal level, where there's concurrent jurisdiction there. They kick back a lot of cases because, unlike the state prosecutor's office, they want everything wrapped up in a bow on the federal side before they're even look at it. And so, I mean, it's not that you have to say that for every single case, but in Rhode Island, when I used to work at the Attorney General's office, we had what was called the rules of the road. And the rules of the road, one of them I thought was one of the most important ones. Sometimes you have to say no, even though there's a lot of public pressure, maybe political pressure to bring charges or get a conviction on somebody. Sometimes the right answer in the interest of justice is no. And to be an effective and good and ethical prosecutor, you got to be able to have the guts to make that decision. And you don't bring charges unless you have a reasonable probability of success at trial on the merits. And I think that's unfortunately lost on some prosecutors in this day and age. I think we're seeing, particularly right now, a lot of political prosecutions, not in, not just on the federal level, but in states in general. We've seen them for the last couple of years, that I think they're just made just basically to please the public, please the outcry of certain groups that want this person or those people prosecuted for whatever reason whatsoever, even when reasonable people looking at that case would say, I just don't see any evidence to bring criminal charges against them. Have you seen similar things where you are, Mark?
Oh, of course, yes, I have. And the oftentimes the prosecutors and district attorneys who say no, it makes all the difference. They get a reputation for saying no. Policemen eventually respect it, even though they may not disagree, but they're looking at things a little differently oftentimes. The public sometimes disagrees, but the easy thing is do the political consideration. But I've seen many a prosecutor that failed them, where they get the reputation of, if they say yes, it's a good case, they know it's a good case. They say no, there's a problem, let's make it better, or let's see if we can find more evidence. They get better reputations, they hang around longer, they usually get reelected. It's not a guarantee, because prosecutors and district attorneys are a very political position. And if in most places they're voted upon by the voters get upset, they're out. But that's part of it. You have to accept that. And those prosecutors who are lazy and say no get a bad reputation. But most prosecutors who say no, they get a good reputation, and they hang in they get reelected as long as they want to. And if the upsettedness usually goes away. People have a short memory on those things. And people who are engaged in politics know that, and know that, common thing that it's, for things that are in the public's eye, 30 days is a long time. That's ancient history.
Sure.
So do the right thing and say no when it's not a very good case.
Absolutely, I agree, and it is an unfortunate reality that these positions are political in nature. And it's something that I think that is one of the failures of our criminal justice system, is that it is such a political situation where you have prosecutors who are elected and making these decisions that are based on things other than the law and facts, and whether or not they're able to prove their cases. It's one of the things that I'm certainly not going to change that if I were to be successful in my run, but it's one of the things I'd like to address in my one of the things I'd like to address in an administration that I would be part of. But I do agree with you. The ones who get the reputation of being able to say no, being able to call the cases straight, as I call it, and not allow everything else to come into play when they're making their decisions, are the ones who tend to stick around and get the good reputations, even if they have to make a couple unpopular decisions along those ways. And I think that, especially when you get the respect from the defense bar and from the bench, as a prosecutor, for being a straight shooter and being somebody who can call it as they see it, I think that is the highest honor you can get as a prosecutor.
And the prosecutors, some realize that, some don't. But there was a race in Indianapolis where one of the candidates, who actually I consider a friend, I think he just kind of wasn't thinking, really criticized defense attorneys for representing some types of people. And what happened was lawyers, civil, former prosecutors, defense attorneys, showed how influential they are. We very rarely hype up too much, but people come to us and ask us about, what do you think of the people running for district attorney? And when they make a major faux pas, we then get on the horn and we tell people actively, this person was in the lead and ended up losing. Now, he's gone on to have a great career and probably regrets what he did in the heat of the campaign. But, that is a check and balance in the politics, and that people go, you just can't do it. It's a truism. Criminal defense attorneys, as you know, we sometimes represent people that are kind of, to use the word that I like, icky. They're bad people. The question oftentimes, more often than not, is, did they do it? We can't deny that they've had a bad history. Or, and I find this very, very frequent, they've been overcharged. And yeah, they've done something, but my gosh, you didn't do what you said. So we've got a dispute here.
Right.
You know, that you're going to convict them of the more minor crimes because that's what they did. But the trying to say that it was worse is the jury's going to say no, and oftentimes they do.
Right. And I think as that is one of the major problems we've got in the criminal justice system is overcharging by a prosecutor's office. And I think we've seen that in some major cases nationally. We saw some people who everybody thought was going to get convicted, they get overcharged, and then they come back with an acquittal or something on a very, very minor charge that was probably charged along with the rest of the case. And I think it's just as grave a sin as making a political decision in a prosecution is overcharging because, you're right. There is that tendency for a jury or a judge if they're viewing the case to say, you know what, I may not like this defendant. I may agree with you that they did something, but they definitely did not do what you're charging them with, and we're not gonna go with that. And it's it was one of the things that I criticized when I was in the prosecutor's office, is that you know there's you've got to be critical of your own case. Just because I've convinced myself as a prosecutor of this person's guilt does not mean that has been I've convinced anybody else, any one of those 12 jurors, that judge, or anybody sitting outside watching what I'm doing. So it's something that I think is personally, and this is my opinion, is bordering on epidemic levels right now with all the politics going on with overcharging. So, I couldn't agree with you more on that one, Mark.
Yes, and we've had prosecutors do that. The prosecutor I was telling you about who just died was known for not overcharging, and he now is known for having one of the most effective, great, outstanding, well-organized offices in Marion County's had for a long time. Well, that's because he didn't overcharge, for one thing. He got what happened and got people convicted for what they did.
Which is what our system is designed to do, and it's what our Constitution is there to protect us from. And moving to to another case that I really would like to discuss, talking about our constitutional rights and protecting them. I was very pleased to see recently the United States Supreme Court come down on a case that initiated here in Rhode Island. The
Yes.
Cranston Police Department had done a quote unquote welfare check on a gentleman, went to his home, said that, somebody had said that he's had an episode, go check on his well-being. And while they're there, they decided they were going to seize his firearms and refused to give them back. And this gentleman sued in the U.S. District Court, the District of Rhode Island, the police department to get those back. The U.S. District Judge in the this is the Caniglia versus Strom case. The U.S. District Judge, ruled in favor of the police department, saying that they had a right to go into that home for community caretaking purposes, which generally is relied upon as an exception to the warrant requirement of the Fourth Amendment, and upheld their ability to take those guns and keep them. The First Circuit Court of Appeals upheld that ruling, and they appealed, and they petitioned the U.S. Supreme Court for a writ of certiorari, and the court said, yes, there is an exception to the Fourth Amendment that allows for community caretaking, and sometimes you don't need a warrant to do that, but that's generally in the case of you're on the streets, you're patrolling, you see somebody who needs some help, you're in a situation where you may be checking an automobile, somebody inside of an automobile. But when it comes down to the home, the courts have been very steadfast, in my experience, protecting the sanctity of one's home and your protection of one's home, and requiring police departments and law enforcement to get a warrant before they go into your home, except in extreme circumstances. And the court, I think, in this case, put a big mark on Fourth Amendment law, saying that you cannot just rely and fall back on this community caretaking standard when you're going into somebody's home. It may apply in some cases, but you just can't. It just can't be the catch-all when you can't find when you can't find a warrant, or you can't find another exception to the warrant requirement. Is that what you took out of this case, Mark?
Yes, I did. And this is another example of the appellate judges, this time being the Supreme Court of the United States, saying, we don't like legal I gotchas. You're trying to take this caretaker standard, community caretaking standard, which the district I practice in is the Seventh Circuit, or in the federal courts. They were the ones that came up with this 40, 50 years ago, that case really was compelling. And that was what the attorneys for the police and for the prosecutors were saying is, well, this is just community caretaking. And this is amazing. All 9 justices, with about 85% agreement, there was a couple of not dissents, but concurrences, mostly to even think about talking more about it than probably need to be done. But they wanted to make a point where they may be going in the future about this, almost like a warning shot, like, cut it out, folks. Don't do this. And one thing, the best way I can describe it was this community caretaking stuff, and with cars being more readily to search without a warrant. Well, I have yet to see an impound lot for mobile trailers on up to fixed houses on foundations. So you may, and the courts mentioned that. They say, yeah, you have an accident, you may have to move it in an impound. Maybe you should be able to take an inventory, because if you don't, the people will say that all types, there was $1 million in the trunk and you took it. And if you happen to find something because you're doing something legitimate like an inventory to protect yourself, we're going to say, nope, this is an exception, exigent circumstance, or whatever they want to say to do that. But no, the home, it's like, it's there and it's not going to go anywhere. And yes, that means you can go to a judge and take the time to say, here's why we think we should go in the home, and have a judge decide that's okay. There's just nothing like that at all. And I think it was the correct decision. And the fact that all the judges of all different stripes in the way that they look at the law, they actually have a lot more commonality than people might think, even though they came from different political parties. But oftentimes you have 6-3, 7-2, 5-4. This was 9-0 slam dunk.
It really was. And I think that, yeah, and I think I agree with you. It's good to see that when you see these 9-0 decisions, and even though there were some concurrences that suggested that they may go further in the future, protecting this, we've had a few 9-0 decisions coming out recently, and for all the, I'll call it, this is my word, of course, but for all the hysteria that was going on for the last few years when former President Trump was appointing justices to the Supreme Court, saying that this was going to be some, wild conservative court that's going to be, doing constant 5-4, 6-3 decisions. It hasn't been that way, at least in this term so far. And
No.
And I think that is a tribute to the justices court who made the pledge when they were appointed that they were going to put their politics aside and decide the case on the law. And I'd like to see more like this. And I certainly was. I think it was Justice Kavanaugh in this case that gave the concurring opinion that suggested that they may even go further if this actually comes up before them. And I thought that was an interesting concurring opinion that, kind of foreshadowing, the kind of cut it out, guys. You're not going to get away with this if this keeps coming back before our court.
Yeah, it was good to see. And I'd like to point out now, it's amazing the judges who like each other on the Supreme Court, they socialize, but people think that they're completely different approaches to the law. And they do have different approaches to the law, but they tend to have a lot more commonality, and they actually socialize. And you have Justice Thomas and Ginsburg, Scalia, all these people, Breyer, that they go out and eat and talk and have a good time and maybe debate some stuff, and just like we do with our friends. And right. They're all trying to do the same thing. I don't see any right now on the Supreme Court that I don't think is trying to do the right thing. And as an attorney and being before lots of judges, We all see judges where we go, I don't know about them. But this is one of Sotomayor, from a constitutional standpoint, not always, to me, is one of the strongest ones. And so she's often with Gorsuch, who's considered a Trump appointee. It's not unusual to see those two on the same page because they both have this very this is important stuff, folks. So we're going to treat it importantly type persona. And they tend to err on the side of, well, occasionally a criminal will go, but that's better than people who shouldn't be prosecuted not going.
Yeah, and I've seen that. I think I've seen that pretty consistently since at least Justice Gorsuch's appointment to the court. There's been a strong defense of the rights of the accused, criminally accused, and in the mold, I would say, of Justice Scalia, that they would consider him a quote unquote conservative justice. But when it came down to criminal justice rights, I mean, there was probably nobody on that court that was stronger than Justice Scalia in defending the rights of people accused of crimes. And, I think this case, there wasn't even an accusation of a crime. This was really just right. They went into the house, they were concerned about him. Okay, fine. But they took his property. They wouldn't give it back. We're implicating, property rights in here. Not only that, but we're talking about the Fourth Amendment, which is, in criminal law, there's very few things more important than the Fourth Amendment and upholding that. And, we had to have the United States Supreme Court weigh in on this whole situation, which didn't even come down to a criminal charge. It's not like this guy was going in there holding somebody at gunpoint. And they charged him, and there was go through a whole trial. This was just to get his property back, and so that's what I found most offensive. Yeah, exactly. I mean, especially when you have, like you said, you have a house that's not going anywhere. You have the amount of time you need to get. You can put an officer outside that house to make sure that evidence is not spoiled, doesn't get tossed away while you go have another officer go apply for that warrant. The exigent circumstances doesn't apply. The community caretaking can only take you so far. And I'm glad to see that this case was pushed to the level that it was, because there are other means for a law enforcement or courts to take guns out of hands of people who probably shouldn't have them, or have some other issue going on in their life where there is a proper role to keep that out of their hands. And I think this kind of just pushing people in the direction of doing things the right way. And it's interesting from my perspective that this came out of Rhode Island, because now I think that they're going with this case came out or was originated before they implemented the red flag, the so-called red flag laws that a lot of states are putting in place. So I think this is I think as far as Rhode Island is concerned, this is going to push people to see a lot more of these red flag or extreme risk protection order cases, because that's the way the state law now is set up to deal with these types of situations. Now that the so-called catch-all community caretaking exception to the warrant requirement has been significantly narrowed, I would say.
I believe the red flag logs will be the next area where there'll be abuse trying to do a workaround against the U.S. Constitution. Excuse me. And also for the Indiana Constitution, which I like to point out has stronger interpretation of the Bill of Rights than the Supreme Court of the United States does for the federal Bill of Rights. We have actually identical provisions, but our Indiana Supreme Court interprets it way more stricter. It's really nice to see that they care about those things. So I'm very proud of that. But it's one of those things that when I first started practicing law, we all learned quickly where the judges like to go to the bars, restaurants, theaters, etc., because the prosecutors did, because they'd had to search them down. It was a hardship to get a warrant sometimes. Now with Zoom and everything, it's like, oh, no, let me step outside for my restaurant party. 2 minutes later, they've authorized it. They've approved somebody's written the order and sent it to them. And it's like, okay, at least somebody somewhat independent decided that the police aren't going off the wall on this. It's getting even harder for the police to say it's too hard to get a warrant and that we don't have time. No, it's and in a court system in Indianapolis where I practice, we've got 60 judges all around here. And one judge, not all do the criminal stuff, but out of the about 30 that do, one's always on call. So they're there. That's their night once a month that they do the weird stuff that needs a warrant. So it's not
Exactly.
that hard to do.
And
And it's good to
particularly
have
in the
that because
age,
sometimes they say no.
yeah, exactly.
The judges
And
do.
particularly in the age, yeah, and particularly in the age of everything that's happened since this COVID pandemic has come out, where things have become remote and doing things like Zoom and WebEx and those types of situations. The access to these judicial officers has been, in my opinion, improved. Especially here as a practicing attorney, you're trying to get things done. You have in my experience, we even have email access to a judge that ultimately, prior to this whole COVID pandemic, you wouldn't have normally had. So, I think the
Right.
old argument, you're right, that oh, we couldn't find a judge, we didn't have time to find a judge, and there wasn't one available. And it's not going to carry the day anymore for the prosecution or a police department.
There's a judge in Indianapolis um, who is known as pro-prosecution, but I love being in his court because that he is the type of pro-prosecution that has high standards for the police. You want to get on his bad side, don't get a warrant when you really should have. He will punish you because it's like, that's bad policing. I don't want bad policing to come before my court. If you do a good job and you have the facts, I'm going to convict the person at a trial before me. But if you don't have that, he'll punish for that. And I think he's got the good read on the warrants. Do it right. When I was a prosecutor, when I first started off, a deputy prosecutor, I hated it when I had to work hard to defend a case where there was an issue whether a warrant was needed or not. Well, I'd rather them just had gotten the warrant so that we didn't have to spend half the case arguing on whether a warrant was needed or not. It would have saved everybody so much time.
Absolutely. I always used to tell the police department, because I worked in a lot of the smaller counties in Rhode Island when I was in the prosecutor's office. So I had a lot of interaction with the local police departments. And if I always used to tell them, if you have to come and ask me if you need a warrant for this, get the warrant, because it will save us all a lot of time. Because if
Yes.
you're thinking it, you probably already know the right answer to that question. And it will save that. And there's a judge in the Rhode Island District Court who's very similar to the one you're describing. She's known to be very pro prosecution, but holds the police department and the prosecutors to a very high standard. And I know when I was a prosecutor, I did not want to go before that judge if there was poor policing or poor prosecuting, or you were ill prepared, because didn't matter that she may be a little bit tilted towards the prosecution. She would ream you out if you did not do it the right way. And I think that encourages good policing. It encourages ethical prosecuting. And, I wish there was more of that, to be quite honest with you. Certainly as a defense attorney, when I don't have a great defense for a client, it's certainly not fun being in front of that judge. But I think that there's judges that go the other way. And as a prosecutor, I was in front of judges who were very pro-defense, and I enjoyed being in that court because they held me to a high standard as a prosecutor. And of course, I enjoy being in that court now as a defense attorney, just because you're going to get a fair shot, and you're also going to be treated well. And that's one of the few things I ask for, is that we're all professionals here as far as the lawyers and the judges are concerned. Just we should all be able to have our roles, do our jobs, and be civil to each other. And that's one of the things that I think sometimes is missing in our judicial system, that kind of gets in the way of justice.
No, I agree with you. And you have high standards like the federal court district attorneys did. And again, I've seen an erosion of that. And I attribute it more to Congress adding more and more things they have to prosecute. You get too many things to prosecute, you can't be as selective. And boy, the U.S. attorneys' offices across the nation, when they're being selective, they make a huge point when somebody's convicted, and they do it right. And it's like, wow, maybe I shouldn't be defrauding the government this way. I mean, it made a huge point. I think it was a very effective way to do things. Now it's like, they're sloppy. And not all of them are. They still have really high standards. But I don't like the trend I see and the pressures they have. And I actually blame Congress on it because they're overloading them. The state court prosecutors have for decades have been overloaded with too many laws. A good thing about COVID, if I could mention, is there's reform efforts in Indiana to change things. There's been a lot of changes in our driving while suspension laws that are now fewer punishments, trying to keep people on the road, trying to keep as few people in jail as we really need to. Former legislator put it this way: the people who irritate us should be on probation. The people we're scared of should be in jail. We're putting too many people who irritate us in jail. Let's stop that. I mean, so I see that we're getting to a point where maybe we're going to get better prosecution, and the people who really scare us we can concentrate on and put them in jail if they should be there because they're a danger to us.
Yeah, absolutely. And there's been over the last few years, I should say, a similar push to decriminalize things like first, second offenses of driving on suspended or revoked licenses, decriminalization of certain controlled substances, or at least, taking them out of the felony category into misdemeanor categories. Try to concentrate on the people who really are a threat to society, threat to other people. And I really do believe that trend should continue, not to the exclusion of all crimes. We shouldn't be decriminalizing everything to the exclusion of simply violent crimes, in my opinion. But we should be concentrating on the ones that really pose the biggest public threat. I mean, and you're right. There are other alternatives to jail that we can use to discourage the unwanted behavior that may not rise to the level of murder, sexual assault, robbery, that kind of thing. And we should use those tools more often. And that can be probation, that can be deferred sentencing agreements, that can be diversionary programs. And I'd like to one thing I will compliment in Rhode Island is the recent addition of the court diversionary program, where they've accepted a lot more of these nonviolent offenses into the diversionary program. I think they need to refine it a little bit, because now everybody's overloaded, and you've got people who are carrying 200 cases on their caseload and they can't pay attention to everything. But that can be fine tuned. But the idea of it is good, and it's one of those situations where that has a possibility to be a good trend going on down the line if we have the right people following it and following the trend of that. So I couldn't agree with you more there, Mark. And I just want to end the show with saying thank you very much for your insight on everything that you do here. I think that your years of experience on both sides of the aisles, your constitutional background and what you do right now has been a tremendous benefit to everybody who's been watching us. And I really do thank you for everything you've provided us with tonight. And please feel free to take this minute or so to tell everybody where they can find you if they're watching, if they want to get a hold of you.
Well, Chaz, I've enjoyed being on the show. This was very enjoyable. And as you know, lawyers like to pontificate, so you gave me a chance to do so. So thank you. Where you can find my law firm, it's Indiana-attorneys.com is what our email address is. You look up Mark Rutherford, Libertarian. This is not being political, but this is just what happens. I find those three key words get all my law firm stuff up there, as well as some other stuff that is out there too. So.
Well, Mark, I again, like I said, I appreciate the insight that you've given us. I've had I think it's been a very interesting discussion that we've had. I love to have the opportunity to discuss constitutional law whenever I can, and particularly the protection of the rights that are provided to us in our Constitution. So again, I really thank you, and I'm sure our viewers thank you as well for your insight. For those of you who are watching, who watch every week, I appreciate you tuning in as always. Again, I'm Chaz Calenda. I'm at the law firm of Inman and Torgy here in Coventry. You can find me at itwlaw.com, and that's at 401-823-9200. And for those of you who are more interested in my campaign to be the next Rhode Island Attorney General, you can find me at chas4ag.com. That's CHAS, the number 4ag.com, if you'd like to find more about my campaign. So thank you for all of you for tuning in to another episode of Chas Calenda, Attorney at Law. And Mark, again, thank you for joining us, and I hope to see you again on a future episode.
Thank you. Hope to be here again soon.